Yes, sir.
My lord, this is regarding in HMA 24 case number 61/2025, interim maintenance order of 30,000 is passed by the learned 7th additional Parasat. So this 30,000 order is 15,000 for the wife and 15,000 for the minor daughter. This order is passed even when I was complying with a maintenance order of 20,000 rupees, 10,000 for the daughter, 10,000 for the wife in the domestic violence case. This was ordered by the second additional judicial magistrate, Bosidhat, in case number C67/21 in the domestic violence case. Now this 30,000 is ordered here. The ground that is mentioned by the learned trial court is that the opposite party, that is me, I could not show any proof of income for the wife. But the fact is that in my assets and liabilities, I declared the income level of the opposite party.
Show me the documents.
Achha.
What
Lord,
have you declared and what
Page
has
number 45.
page 45.
45. This is the assets and liability that I submitted to the Honorable Trial Court. Page number 45, if para 2.
Page 45,
45,
para 2.
para 2. Here I have declared the monthly net take home salary is 43,720 rupees. 45.
Yes. This is for your wife. And what is your income?
My income is 62,850.
Page.
Achha. Page is 42. Para F3.
F3. Very well.
This is what I have declared in my assets and liability.
Right.
But the Honorable Trial Court has considered my income as 62,850.
Very well. So lesser than what you have declared.
This 62,850 I have not mentioned in my assets and liability.
You have mentioned 68. He has taken 62.
62. This amount is considered from the written objection that I have submitted to the learned trial court. And my entire assets and liability is not at all checked by the learned trial court. And for the opposite party, I have submitted 3 months of salary slip, which is attached. Is page number from 53 to 60.
Page 153.
No, 53.
Page 53.
53. So here, page number 54, the joining letter is there. She is working in as a assistant teacher, which is recruited.
This has not been examined.
No. And next, page number 55, my lord, 55 and 56 is the recommendation letter by the West Bengal School Service Commission. This is a permanent post, my lord. And page number 57, this is the approval of the district inspector for the pay level that is approved for the opposite party. Page number 57.
Page
57.
Page 57. Page 56.
And from page number 58, 59, and 60, 3 months of pay slips were annexed.
Yes.
Page number 58, 59, and 60.
Seen it, yes.
If readability is the issue, my lord, so page number 62 has a very clear readable format for the pay slip for the month of September 2025. Page number 62. It is actually the content of page number 60, but it is not that much readable. So I have annexed the same page as annexer C, page number 62. Here, my lord, the salary is clearly written 43,920. 43,720 rupees.
720 or 920?
Page number 62, my lord.
62 is showing gross salary 43,920. Acha, net salary is 43,720.
This is for the serial number 1, Sarmishta Mandal.
Yes, it has 2 components. Gross is 43,920, net is 43,720.
Correct, madam.
Yes.
So net
Next.
salary is 43,720 rupees now. So all this I submitted, but still none of these pages
Have
are
been
actually
considered.
considered by the learned trial court, and it is mentioned that no proof of income is submitted by the me. matlab, I have not submitted anything. Also, my lord,
Where has he said this, that nothing has been brought on record by you?
my lord, page number 15, 15, page number 15, para 5.3.
Page number 15 of what? Of your
Total, whatever page number I have mentioned, there page number 15, which is actually the order. Page number 15.
You
So kindly
refer to the paragraphs of the order, because I can
Paragraph is
understand.
5.3.
5.3.
Huh.
Yes.
Here it is clearly mentioned he could not show any
document.
document of
Yes,
income
I've
of
seen
his
it,
wife.
seen it.
My lord, here in the main order, just a few sentences I want to read it out. Page number 14, my lord, one page before, and para 5.1.
Para 5.1.
It
Yes.
says, I have heard both sides at length. I have also perused the statement of assets and liability filed by the petitioner.
So
The
not
petitioner is
yours.
the wife, not mine. But I also submitted the assets and liability as per the direction of Honorable Supreme Court. And I don't know, my lord, why that was ignored. Also, my lord, page number, next page, para 5.2, it says, line 4, the respondent husband is a salaried person, whereas he earns rupees 62,850 per month as on 31st July 2025 as per his own admission. Where from this amount is coming? My assets and liability says something else. So it is only the written objection which is considered by the learned trial court.
So in the written objection, you had written that that is not hurting you in any case.
It is not hurting me, but what is hurting me is the assets and
That
liability
your,
that I have
your
submitted.
wife's income has not been considered at all.
And my lord, my 6 months of my life, I am running across different courts now because of the order for which, like, I had no fault. I followed whatever legal procedure is there, whatever Honorable Supreme Court has suggested me, that I have followed. Totally, it is ignored. And this 30,000 order has been passed, although I was complying an order of 20,000 rupees in the domestic violence case. My lord, this is the bank statement. This
Bank
shows,
statement not required.
my lord, that domestic violence case, every month I am paying this amount. So that is there for the last
Domestic violence case
1
order
year.
is there on record, not required. The domestic violence case is there, I mean, order is there on record.
no, that's not
It is there. It is there, my lord. It's page number 13, para 3.5.
3.5. Yes.
3.5. This is the observation made by the learned trial court. On the other hand, the respondent is only a salaried person, whereas he earns 62,850 per month on 31st July 2025. The respondent husband is paying rupees 20,000 per month as maintenance alimony to the petitioner as per the order of the additional judicial magistrate, second court, Basirhat. So this is also observed by the learned trial court, 7 ADJ Barasat.
Very well.
My lord, once this on 31st of January, she was recommended for this job. Around 45 days, on 18th of February, she filed this case telling that I don't have any source of income, so I am filing the case. Whereas the petitioner, opposite party, was knowing that I am having a job, I am having the appointment letter, and 2 days after, she joined the school. And as per the Supreme Court, my lord, this is Rajneesh versus Neha. My lord, page number 62, declaration 2. Page number 62, declaration 2. I undertake to inform this court immediately with respect to any material change in my employment, assets, income, expenses, or any other information included in this affidavit. This affidavit is annexed by the opposite party in page number 73. She has signed, the opposite party has signed. So, as per the direction of the Honorable Supreme Court, she is telling to the Honorable Court, I will declare any change of my income status. And after that, she has got the job. She was knowing on 31st of January, I am having a job. After 45 days, intentionally she has declared, I don't have any job. And she has filed this case. 2 days after, she has joined the school. She is having a monthly salary of 43,720 rupees. And after that, almost 8 to 9 months after, this order has been passed, and the opposite party has not felt any need to inform about her income status. So, my lord, this opposite party has not approached to the court with clean hand. And for last since 2021, this opposite party is clearly misusing this legal system to exploit me and to extract monetary benefit from me. My lord, also, from the same Rajneesh versus Neha, page number 36, para G, which also says, if during the course of the proceeding there is a change in the financial status of any of the party, or there is a change of any relevant circumstances, or if some new information comes to the light, the party may be submit an amendment supplementary affidavit
I've seen
which
it,
could be
seen it.
considered by the court. My lord, also a 340 was initiated by me to the same learned trial court.
That is different.
And
That is
before,
not part
my
of-
lord, before passing this order,
Very well. That is
Ah.
not part of the proceeding here. You are on the order which has been passed under section 24. You made your submissions. I'll hear him now. Yes.
My lord, it is the true fact, my lord, she got the appointment. My lord, the application filed on, my lord, 18th February 2025. She got the appointment, my lord, the 20th February 2025. So before getting the appointment, she filed this application.
Very
Well,
well.
one
But
thing
after
is-
getting the appointment, she should have informed the court that
My lord,
this is my income.
one
She
thing,
could
my
not
lord,
have
they
continued
have
with the false-
they have annexed everything, but kindly see the, my lord, the written objection in page, my lord, the 27.
page
Oh,
27,
sorry, my lord. My lord, page 35, my lord, kindly see.
page 35,
Paragraph 22.
paragraph 22.
My lord, that since the February 2025, the petitioner has a job, her exact monthly salary is not known, but yet approximate, my lord, monthly salary would be in the range of 80,000. But he annexed the document, but he submitted exact salary has not been known to me. But subsequently, this document has not produced before the court. Well, I do not know how he get the
Very well,
statements of this, but it is
uh,
the fact he got the appointments.
You
Second
allege
thing
that
is,
he has also falsely alleged, but in any case, it is not your case that you are not earning.
no,
It is
that
not
is
your case. It is not your case that you are not earning. Therefore, in such circumstances, you are obliged to bring it to the notice of the court that subsequent to the filing of the application for alimony pendentity, I have secured a job and I am now gainfully employed. Now, this fact, if you have suppressed from the court, then that is sufficient for the court to annul the order.
my lord,
granting you alimony.
one thing is that at the time of filing this application, my lord, he is not.
Very well.
Subsequently,
At the
thereafter,
time
my
of
lord,
filing, I am with you that at the time of filing you were not in the know of it, therefore you did not file the documents. But while the proceedings were pending, you got the appointment. At
That
the time
is-
of passing of the order, you knew. At the time of making arguments, you knew. At the time of the when the proceeding were being, the carriage of the proceedings, you knew. All these times you suppressed. Now all of this can be washed away.
No, my lord, I am not. I am telling my lord, this is not the sufficient because the document is there. My lord, the learned code below that has not been, my lord, disclosed by the petitioner. There is the salary.
Very
term,
well.
That is,
So,
my lord,
that is
get-
oath versus oath. That is oath versus oath. That is not going to take you anywhere.
but
Now,
that's why.
the moment it comes to the notice of the court. And how will you justify the court's observation that he has not produced any document? He
Yes,
has
that is,
produced
that is the fact,
Now,
my lord.
then on all counts, why should this order be not set aside?
My lord, one thing is, my lord, the only insufficient income is not there. That is, he is earning 2 lakhs.
It's not,
This,
he has
my lord,
not-
this
he
is
has
the
not
dispute.
expressed
Yes,
anything.
yes.
He has just come to the conclusion on the basis of his own observations, which are absolutely contrary to what is there on record.
My
He
lord,
should have gone by the records.
I am bringing one thing, my lord, the remand back the matter for the fresh hearing, because, my lord, the document is there. My lord, the matter should be heard in afresh, because otherwise, my lord,
My
there is
lord,
no sufficient, because
may I
my lord,
have to
everything
submit
is,
on this?
one thing is the, my lord, conduct of the, my lord, the petitioner is that, for that reason, they filed a criminal case.
Very well, that I am not going
That
to
is, my
comment.
lord, they have annexed it.
I am not going to comment on that
My
because
lord, the
that-
daughter is with me.
My lord, please
allow
allow me to
to
submit on
complete
this.
the sentence which the
Yes,
court has begun with.
Forget.
I am not entertaining any
Yes, yes.
observation or any proceeding as regards you making any false statement or the petitioner making any false statement. Those are proceedings out of the purview of the court, because today my jurisdiction only is confined to the order which is challenged before me. So far as this is concerned, I find that this order is perverse. It has to be set aside. Yes, sir.
My lord, on this, my lord, this written objection was submitted in the month of September. I filed all these RTIs and that school was not replying to me. So when I filed this written objection, at that time also, the RTI reply was not received by me. Only this joining letter I found, they replied. So the salary related information they was not providing me. So I was forced to write letter to the district magistrate of that. After that, district inspector of the school, then only they replied all the salary slip.
Very well. I am
After-
setting it aside, sending it back for fresh consideration.
My lord, that assets and liability for both the parties.
So all the documents will have to be considered afresh.
My lord, if it is sent back to the learned court again, then again, like I have to roam around this district court of Barasat. Again, in the DB case also, this order is based on the level when wife was not earning. Then again, I have to go back to Basirhat also.
No.
My lord, this
That
That is the
order is
separate
not
issue.
being interfered with.
Yes.
That we are paying. In this order, I'll clarify that the court will take into in any case, it is clarified in Rajesh versus Neha also that it is one alimony which is to be paid, which will include
Yes,
the
yes,
other also.
no, I am praying if my lord,
Pay two amounts.
I am praying from the my lord, if you can pass order today itself for the maintenance, because assets and liability
I will
for
have
both
to
the
assess
parties.
evidence then.
Yes, yes.
I will have to assess evidence which is not the jurisdiction of the revisional court. Appreciation of evidence is not the jurisdiction of the revisional court. That can be done in appeal. I don't have appellate powers.
My lord, tomorrow that date is there for execution. So this,
Right today.
okay.
Execution
So
of
I'll get a copy of this order today, my lord.
Even if you don't.
No, I am informed already.
Okay.